Hello, I'm Jaspreet. I'm company secretary by profession, and here is we are doing revision of Companies Act. Disclaimer that this is only for revision purpose, and for any practical life situation, you are recommended to refer to updated relevant laws. And now let's continue. So we are taking the book Sarans by Institute of Chartered Accountants of India ICAI, and I find it very appealing graphically. So when I started reading, I found it very attractive, and I thought of creating a video out of it itself. So we were discussing types of companies, and next is company Nidhi company. So for Nidhi company, we have section 406. So Nidhi or mutual benefit society means a company which the central government may, by notification in the official gazette, declare to be a Nidhi or mutual benefit society as the case may be. So it can be in the form of a company, it can be in the form of a society, mutual benefit society, and central government will determine. So here the purpose is that people join together, accumulate resources so that they can buy things cheaper and maybe similar activities, but intent it is for the mutual benefit. And next is dormant company. So dormant company is defined in section 455, where a company is formed and registered under this act. What what is the purpose? For incorporation, for a future project. Okay. First purpose can be that company is incorporated and registered now, because at times registration may take time. So we have timely on our future plans, based on our future plans, already incorporated a company. Or another possibility is to hold an asset or intellectual property. Certain assets can be transferred to this company, intellectual property can be transferred to this company. It will hold those assets and intellectual property, and has no significant accounting transaction. So there is no significant accounting transaction. Okay, there may be day-to-day accounting transactions like paying ROC fees, but there is no significant accounting transaction. So then this is termed as dormant company. Okay, it is for future project, or it is to hold assets or intellectual property, and there is no significant accounting transaction. Such a company or an inactive company, okay, we can call it an inactive company, may make an application to the registrar as prescribed under the relevant rules for obtaining the status of a dormant company, which means first it gets incorporated as a company and then we obtain a dormant status from ROC. Registrar, on consideration of application, allow the status of a dormant company to an applicant and issue certificate. So certificate is also issued. Then, in case a company which has not filed financial statements or annual returns for two financial years consecutively, the registrar shall issue a notice to that company and enter the name of such company in the register maintained for dormant companies. So registrar, if a company fails to file financial statements or annual returns for years, two consecutive financial years, then the registrar shall shall issue a notice. So it is a responsibility of registrar to issue a notice and enter that company's name in the register of dormant companies. Inactive company. Inactive company which has not been carrying on any business or operation. Okay, so it is not carrying on any business operation. Number two, has not made any significant accounting transaction during the last two financial years. Again, word is significant. Regular payments are allowed, but there is no transaction as to business. There is no significant accounting transaction during the last two financial years, or has not filed financial statements and annual returns during the last two financial years. So has not filed. has not done its annual filing for last 2 years, has not made any significant accounting transactions. It can be it has filed its financials, but financials do not reflect any significant accounting transaction, and there is no business. It is an inactive company. Now comes the word significant. Significant accounting transaction. Significant accounting transaction is any transaction other than payment of fees by a company to the registrar. So we will pay ROC various fees, like there is change of director, form is filed, fees is paid, and maybe there is requirement of certification by practicing professional, a fee is paid. So payment of fees by a company to registrar. So the payments made to the registrar is not a significant accounting transaction. Payments made by it to fulfill the requirements of this act or any other law. So if we are only making sure that the company is law compliant just to fulfill bare minimum legal requirements, then those payments do not qualify to be a significant accounting transaction. Allotment of shares to fulfill the requirement of this act. Again, allotment is only for the purpose of fulfillment of requirement of this act, then it is not a significant accounting transaction. And payments for maintenance of its office and records. So basic office, basic infrastructure is being maintained, then records are being maintained in correct order. So these basic requirements, if these are requirements are fulfilled and the cost is incurred, transactions are done, then these are not significant accounting transactions. Okay. So this was about dormant company. Before that we discussed about Nidhi company. Section for Nidhi company was 406 and for dormant company is 455, 445, 455. Okay. So next we move to memorandum. So now the topic has started, incorporation of company. At the time of incorporation, one of the main constitutional document is memorandum of association. And in memorandum of association, we have 5 key points. So here we have 1, 2, 3, 4, 5. So first is name clause. So name clause is name with which company is registered. Memorandum will contain the name. First, at the time of incorporation, we get name approved, and then that approved name is entered in the memorandum. Alteration. Alterations we will cover in next discussion. First, we are discussing contents of a memorandum. Name clause. Second is domicile clause. That is state where the company will function, thus where it will hold its registered office. So domicile clause specifies the state where registered office is situated. Next is object clause. Object is very important. At times we do not seek significance, but a company cannot operate any business other than what is allowed in its object clause. So it is an important thing. Memorandum is required everywhere because its objects are to be checked. So object clause contain object for which company is formed and enables shareholders. So this is relevant for shareholders. Enables creditors. This is relevant for creditors. Enables others dealing with the company to know the scope of work. Scope of work company can undertake. So company's work, what all company can do, is limited by its object clause. Any act beyond specified in object clause is ultra vires, hence void. So any act done by the company is ultra vires and void. Company cannot do anything beyond what is stated in its object clause. Next is liability clause or capital clause. So here authorized capital is provided. So in case of a company limited by shares, liability of members is limited up to unpaid amount of shares. So there is an unpaid amount of shares. If there is any unpaid amount, means shares either full per share value, either full can be obtained or partial can be obtained, like a share is of rupees 10. So in the first call rupees 2 are received, then in second call maybe rupees 2 are received. So in case there is unpaid amount, then to that extent liability of member is limited. Company limited by guarantee specifies the amount each member undertake to contribute. Now contribute at which point of time? At the time of winding up, at the time of dissolution. So here members specify in advance that in such an event how much will the members contribute to the company. Company having share capital. So in case company has share capital, then amount of share capital with which company is to be registered. So this is the registered or authorized capital amount. Authorized means this is the limit up to which it can issue shares. Authorized, registered capital. Number of shares each subscriber to memorandum intends to take. Then second is how many shares each subscriber intends to take. That is also mentioned. Name of subscriber and number of shares subscribed. In case of one person company, name of person who in the event of death of subscriber shall become a member of a company. So in case of OPC, this capital clause or liability clause contain name of the nominee. Name of the person who in the event of death of subscriber shall become the member of the company. Next is subscription clause. Subscription clause is section 7 subsection 1 section A specifies that memorandum of association and articles of association duly signed by all subscribers to the memorandum be filed with the registrar. So subscription clause contains signatures of the subscribers who are subscribing to memorandum and also to articles. So they sign memorandum, they sign articles, and they subscribe to the shares or specify their liability. Now let's see, can this memorandum be altered? So can we alter the memorandum? So out of these 5 clauses, if we want to alter the name of the company, so alteration can be done by passing a special resolution in the general meeting of the company. Means members can pass a special resolution plus approval of central government. There is requirement of approval of central government. Central government can delegate authority to ROC or maybe regional director or anybody else, or it can directly take up to approve. So we require special resolution plus approval of central government. Then new certificate of incorporation will be issued. New certificate of incorporation will be issued. Next is domicile clause, means state. Company is being shifted from one state to another. In this case also central government approval necessary when changed from one state to another. So domicile clause will change if there is change of state, and then central government approval is necessary. Registrar will issue fresh certificate of incorporation indicating the alteration. Next is objects clause. If we want to alter the objects for which company is incorporated, or we want to add new objects. So alteration. Special resolution through postal ballot is to be passed. So special resolution through postal ballot is to be passed, plus publish in newspaper, plus give exit opportunity to dissenting shareholders. In case of company which raised money through prospectus plus money is unutilized. So what is happening is, for altering objects clause means the main purpose for which company is incorporated, the main purpose looking at which people invested their money in the company, creditors gave advances and loans, and people subscribe to the shares. So if that object is getting altered, then special resolution means members will pass special resolution through postal ballot. Why postal ballot? Because participation of members will increase, is to be passed, plus publish in newspaper. A public announcement is also done, means it is made public. because if objects are getting altered, then we do not know who can get affected. So general public needs to be made aware and published in newspaper. Plus, give exit opportunity to dissenting shareholders in case of company raised money through prospectus plus money is unutilized. Money was raised and there's certain portion. After raising money, we report utilization of funds, and if there is some unutilized portion, then the if shareholders dissent on this point of change of objects, then exit opportunity is to be given, means they have to be repaid. Now next we will see, can liability clause, capital clause be altered? Can we increase authorized capital? Can we increase contribution at the time of dissolution in case of a company limited by guarantee? So here alteration. In case of company limited by guarantee and not having share capital, intending to give any person a right to participate in divisible profits otherwise than as member shall be void. Okay, alteration in case of company. And while discussing this point, especially on the point of guarantee, if anybody is dealing in such company, either having unlimited liability or guarantee, then I'm providing my email. I look forward to getting in touch with you. I'm curious to know why these companies exist, and means what is the intent of incorporating such company as on date. So because I have not experienced and I am curious to know more, so you can approach me and we can have a discussion around this. So we were talking alteration of liability clause or capital clause in case of company limited by guarantee and not having share capital, intending to give any person a right to participate in divisible profits otherwise than as member shall be void. So this is void in case of a company limited by guarantee. It has no capital. Then if it intends to give any person a right to participate in divisible profits, so that right, that this person can also participate in divisible profits who is not a member, then this is void. This is not allowed. Next is articles of association. So we move to articles of association. Memorandum was constitutional document containing overall objects, overall things about the company. Now articles are like rules and regulations, rules by which a company operates, kind of code of conduct for the overall company, like how shares will be issued, how a dividend will be paid, means these portions. So articles cover these. Articles of association. Articles of association contain the regulations for the management of the company. So we know that company is a separate legal entity. Funds are invested by shareholders. Management is taken care of by board of directors. So there is a code of conduct for board of directors. So these are the regulations for the management of the company, how management will operate. Alteration of articles. Alteration is effected by special resolution. So if we want to alter articles, then we have to pass a special resolution. Number 2, alteration of articles may include the conversion of private company to public company and vice versa. Means if a company is getting converted, that also amounts to alteration of articles. However, when public company is converted into private company, approval of central government is necessary. Okay, so if we transition, say, 1% company to private company to public company, in this direction things are okay. If we want to revert back public company to convert it to private company, then approval of central government is necessary. Alteration of articles plus approval of central government to be filed with the registrar within 15 days. Okay, so once we obtain the approval, then we will file it with ROC within 15 days. Alterations once registered will be valid as if it were originally contained in articles of association. So alterations once registered will be valid as if originally contained in the articles of association. Now, what are the steps for incorporation of a company? So if we go for incorporation of the company, first we will reserve the name of the company. Okay, we will apply online and reserve the name. Then we will draft and sign memorandum and articles and its submission to ROC, that will be submitted to ROC. These documents have to be e-filed and e-stamped. Then consent of persons nominated as directors to act as directors to be submitted electronically. So consent will be submitted, consent of persons nominated as directors. So if the company is incorporated, then a person gives consent to become a director to the company. And as the company is yet to be incorporated, so this consent is filed with the registrar of companies. Submission of statutory declaration of compliance and other declarations. So there is submission of statutory declaration of compliance and other declarations. Submission of statutory declarations of compliance and other declarations. What is declaration? So we are committing ourselves that yes, we have complied with law. Yes, we have complied with all the requirements of incorporation. So what happens is when we commit that we have complied, and then if anything is found out which appears to be not in compliance, then we are liable. So it is a declaration that we have ensured all the compliances. ROC fees is being paid, obtain certificate of incorporation digitally signed by ROC, file declaration about address of registered office. So then we will file a declaration about the address of registered office. Note, new requirement of submitting declaration that all subscribers have paid the value of shares agreed to be taken by him and verification of registered office has been filed has been inserted white section 10A. This requirement is needed to be complied with before the commencement of business. So we have time after incorporation, there is a stage before commencement of business. During this period, we have to file a declaration where subscribers are confirming that they have taken the shares, means money is paid to the company for the shares they have taken, and a verification of registered office has been filed, and the office registered office is verified that it is actual physical registered office. This is verified. So in India, we have a requirement of having physical registered office. E-registered office concept is not applicable in India. Then we can commence our business after filing this declaration. Company to maintain minimum number of members. Okay. Now we discussed in our first video also that minimum number of members. So number of members has reduced below 7. What happens is if minimum number of members is reduced below 7 in case of a public company and 2 in case of a private company. So now there is two possibility. First is number of members reduced. No, numbers have not reduced, meaning nothing to be done, which is a normal scenario. But suppose number of members have reduced. Now what will happen? Company carried on business with such reduced number for more than 6 months. Now number has reduced and company has carried on business for more than 6 months. Okay, time period is also gone by. Now every person who is a member of the company during these 6 and 6 plus months and knows, this is important, suppose 6 months has passed, those who were aware they planned to take an exit. Why take an exit? Because what is about to come will make them personally liable. So they exit without informing the new members. So if they do so, then What happens is every person who is a member of a company during these 6 and 6 plus months and knows that company is carrying on business with minimum number of members, 7 in case of public and 2 in case of private. Minimum number of members, company is carrying on business with without having minimum number of members, shall be severally liable for payment of whole debts of the company contracted after 6 months and may be severally sued therefore. So they can be severally sued therefore means severally sued means one member can be made liable for all the debts, whole of the debts. This is the meaning of severally sued because that carries such a liability for the members. So members may try to escape by transferring shares to a new person who is not aware that the minimum number of members has reduced minimum requirement. So person who continues, ठीक है, every person who is a member of a company during these 6 plus months and knows after becoming aware, he becomes liable. Second case is that number has fallen below requirement. Yes, this has triggered. However, company increased the number of members within 6 months. So if number of members is increased, then no further action. So as no further action was there, if this had not happened, similarly, if within 6 months we have increased the number of members to 7 or 2 as applicable, then no further action. However, if this is not done, then all the present members who are aware, they will personally become liable for all the debts, whole of the debts of the company. Okay, so this is clear. Next, we can continue today or tomorrow. Okay, let's continue. Let's complete this only, commencement of business, this page, and then we move to next. Commencement of business, etc. Section 10A. Company incorporated after the commencement of the Companies Amendment Act 2019. So company is incorporated after this amendment, plus having a share capital, shall not commence any business or exercise any borrowing powers unless, so they will not commence any business and they will not exercise any borrowing powers unless what happens? So means they cannot commence business and means they cannot infuse funds into the company through borrowing. They cannot exercise borrowing powers unless declaration is filed by director. So what is a declaration? What is director filing in this declaration? He is filing within 180 days of the date of incorporation with the registrar. Director is filing a declaration within 180 days, almost 6 months, but we have to remember 180 days from the date of incorporation, that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him on the date of making such declaration. So as on the date of making the declaration, a director is confirming that all the members, all the subscribers to the memorandum have paid for the shares taken by them. So declaration is done by director on behalf of members that funds are received in the company. This has to be filed within 180 days. Number 2 is company has filed with the registrar a verification of its registered office. Now, if no declaration has been filed with the registrar within the period of said 180 days and the registrar has reasonable cause to believe that the company is not carrying on any business or operation, registrar believes, it has reasonable cause to believe that company is not carrying on any business or operation, registrar may initiate action for the removal of the name of the company from the register of companies under chapter 18. So this is chapter 18. Registrar may initiate action for the removal of the name. So action will be initiated for what? Removal of name. Here name is being removed. Here word is may. Earlier we read shall. Shall was in case of dormant company. So then if it is found that company is not carrying on business, then registrar has to put that company in the register of dormant companies. However, if such a declaration is not filed and registrar has reasonable cause to believe, so because there is a possibility of reasonable cause to believe, then registrar has to issue a show cause notice first and get feedback from the company. Then it will be in a position to have a reasonable cause to believe, and then it will remove the name of the company from the register of members. So with this we complete till here. Next we will look at this beautiful graph relating to registered office of the company. So in next video we will start with registered office of the company, section 12. All the best. I will continue to improvise on my video sharing. You may also recommend in the comments what all can be improved. Thank you. This is again only for revision and recalling purposes. Thank you.